On the privacy front, where we're seeing some development is in the class action area, really in the procedural context of certification motions. And while that can signal where the law is going, it's different than having a merits decision. But what we have seen so far is that the courts are allowing the certification of privacy class actions even as the law in that area develops. And one area of particular concern as a result of recent case law, including UK case law, is that companies might be held vicariously liable for employees or rogue employees who have accessed information internally and then misused it. And there have been a number of cases where on certification the courts have suggested that there may be vicarious liability. The important takeaway from this is making sure that you're doing what you can to have appropriate safeguards, such as ensuring that only those who need to have access to information have it, making sure that there are background checks, and taking other measures that would allow you to go to court and say, we did everything that we could have done to ensure that only those who should have access did have access. With respect to cryptocurrency case law, there are really two areas of interest. The first is, how do courts characterize cryptocurrency and what implications does that have? There's a recent case out of British Columbia where there was an allegation made of conversion where someone was improperly given $500,000 worth of certain cryptocurrency, and the plaintiff then wanted it back. And the question was what rights were available to the plaintiff, and one of the important issues was how to characterize it. And in fact, the court in that case said, we don't want to characterize it. That's really too big of an issue for us to decide right now on this record, which suggests that courts are grappling with this and unsure of how they should be characterizing cryptocurrencies. There's a recent decision out of Israel that actually characterizes cryptocurrency as an asset, which in that case had a very significant tax liability. And so I do expect that we will see case law that relates to the characterization of cryptocurrencies. The second area relating to cryptocurrencies is litigation that comes out of the management of cryptocurrency exchanges. There's obviously been a very well-known example of that and insolvency-related litigation, but what actually goes unmentioned when this case is discussed is the fact that one of the banks that actually held the crypto exchange's money sought an application to the court to what's called interplead the money, which means it told the court, we don't feel comfortable holding on to this money because we think that a number of people have adverse claims to it. And court, we want to pay it to you because we don't feel comfortable with what we understand the ownership to be. And so I expect that there will be litigation about how cryptocurrency exchange funds are held by banks. We know that the relationship between banks and other professional service advisors and cryptocurrency firms can be difficult, and that there aren't those same resources for cryptocurrency firms. And this case is an example of that. Companies can take steps to mitigate risk and protect themselves by speaking with legal counsel, including litigation lawyers, to consult on their arbitration clauses and jurisdiction clauses, to discuss privacy policies and practices, and to consult on corporate governance more generally.